Thank you for joining us back here on Just Conspiracy, where we just wish to conspire with other good people of this planet to leave a better world for future generations than the world we all grew up in. I don't know about you, but this week I was watching the Grumpy Diaries verdict come in. Hopefully, if you're watching this video, you saw the video that I made about juries and law and, how a judge can't really judge you. So we're just going to jump right into this, and I'll show you exactly what I'm talking about. Let's check this out.
All right, ladies and gentlemen of the jury, what I need you to do, I need to give the forms back to you. When you find for a defamatory statement, one or more, you need to fill out the compensatory damages. It has to be at least $1 for compensatory damages and up to whatever you feel the damages should be. And for punitive damages, you can put a 0 there, or you can fill out that as well, but I need those lines filled out, okay? All right, so if I can have you retire back to the deliberation room and do that for me, okay?
So a lot of people were really shocked at this. I saw a lot of people online, especially attorneys. I've never seen this happen before. I just thought it was hilarious. You want to know why? Because you're a judicial officer. You're a judge, and you're telling me that the jury found all of the facts for you and you can't judge them? Really? It really kind of seems like this is why a judge can't judge you. Only a jury, if you're a man or a woman. And if you're facing these type of common law actions, which is obviously what we really like to talk about around here. So, I thought that was absolutely awesome. I was like, yeah, you're telling me you got all this power in the world, judge, but you can't judge nobody? That's how the law works? Exactly like this guy's been talking about the whole time? Really sounds kind of familiar. You mean the great state of Virginia gave you all this power and you can't use it without a jury? Anyways, then they went back, they came back out, she read out the verdict, and then this happened.
I want to thank you again for your dedication and your hard work during this trial, and I know I speak for everybody here when I tell you that we appreciate your sacrifices and your time and your public service in this matter, okay? So I'm going to have you go back to the jury deliberation room for one more time, and then we'll release you from there, okay? All right, thank you. Okay. In accordance with law, I will amend the punitive damages award to the statutory cap of $350,000 on Mr. Depp's award, okay? I will set this down for entry of an order, and can we do it on June 24th at 10 a.m. if that's available? All right,
Yes,
Mr. Chu, if you could prepare that order and then circulate it to Ms. Fetterhoff, and we can have all the objections noted on it. All right?
We'll do that, Your Honor. Thank you very much.
All right, and if I get it before that date, I'll take it off the docket, okay? All right, again, thank you to all the attorneys for your professionalism, and you're welcome to come to my courtroom anytime. Well, give me a few weeks, but then you can come anytime, okay? All right,
Thank you, Your Honor.
court is adjourned.
Thank you, Ron.
All right.
All right, you know what I love about this? Jury comes back, they're like, we'll give Johnny 15, subtract 2 million from that. He ain't hurting, he ain't sweating it. He still gets 13 million. 13, kind of the number of judgment, right? Because you got your 12 jurors, and then the plaintiff, that's the 13th member. That's where you get the judgment coming from. And she thanks the jury. Thank you. We're so appreciative that you could bring law into this courtroom. Just go back to the jury deliberation room and you'll be set free. We're not going to keep you against your will any longer. And as soon as the jury's out, okay, they're out. Guess what? I'm going to take away all of those punitive damages except for $350,000. I'm not even going to give them 10% because that's the statutory limit. I was actually really, really upset about this. I really was. And, I thought about it, worked through what I was thinking. And so I started doing some research, and now I'm bringing you this video because this is something that we should talk about. I talk about in common law I'll just bring up the Pleadings in English Act. The Pleadings in English Act was a statutory instrument that once the statute expired, it was just common law. You had to speak the language of whoever you were going after. And that's good common law. So let's kind of break this down, see why it exists, see where punitive damages come from, and you can make your own mind. I'd really like to hear from you what you think about this particular topic, because the jury laid down the law, something that the judicial officer did not have the power to do. But she took away the jury's law with the backing of the state legislature and the executive branch, which gave her the quote-unquote authority to do so. But without asking any of us, members of the public. So I got a couple of things pulled up, and let's just take a look, shall we? So, you know me, with my sources, I always be coming with somebody who actually has an opinion in law and graduated with a law degree, because I'm just a high school dropout and I'm retarded. God just puts law in my heart. That's the only way I know it. I ain't even gonna try and play. So here we go. Punitive damages. How much is enough? This comes out of Civil Litigation Reporter, Volume 20, Number 1, February 1998. And I really like this article because it gives me the ability to kind of show you how the government has legislated away your rights, our rights. They keep putting limits and restraints on our right to where we don't even have the right to pass judgments in law against each other and have them upheld. You just saw that happen in the Johnny Depp Amber Turd case, in my opinion. You're welcome to your own opinion. I'm sure most attorneys are like, blasphemy! Okay, dude. Not everybody's an attorney. Most of us are just common folks. That's why they have common law for us. So we go down here to the development of punitive damages. The award of punitive type damages was common in early legal systems and was mentioned in religious law as early as the Book of Exodus. Punitive type damages were provided for in Babylon law nearly 4,000 years ago in the Code of Hammurabi, Hittite law of about 1400 BC, in the Hebrew Covenant Code of Mosaic law of about 1200 BC, and in the Hindu Code of Manu of about 200 BC. So there's a whole lot of historical precedent for this law. It's not like somebody just legislated it one day. People throughout thousands of years of history have established that this is good law, and this is how it works. And what I like to focus on for the most part is the Code of Mosaic law, although I don't necessarily call it a Code of Mosaic law. Yeah, it probably has been codified, but I just refer to it as Mosaic law or moral law. That's where the Creator puts law in your heart. Punitive damages were first recognized under English common law, and the court Huckle held that punitive awards not only compensated the plaintiff for harms such as mental suffering, wounded dignity, and injured feelings, but also served the purpose of punishing the defendant for egregious misconduct. And what I like to do when somebody's really causing me a problem that I have to answer to is start charging them like an attorney. Okay, like the ACLU, hey, we got to get $80,000 from you, Johnny, for putting together all this paperwork, doing all this administration, writing that article against you. Yeah, you're going to pay us for that too. We're just not going to put that in the actual bill. But you can make up what your time and services are worth when somebody's making you do something. There is no such thing as slavery or involuntary servitude, at least not in law. So just make them a good bill. Soon afterwards, American courts also recognized punitive damages. The plaintiff was awarded punitive damages because of injuries received after drinking wine adulterated by a defendant as a practical joke. The U.S. Supreme Court said the doctrine of punitive damages have received support repeated judicial decisions for more than a century. The Supreme Court says, repeatedly, judicial decisions have upheld punitive damages. Think about that, especially when we go into this next one. By the mid-1800s, as punitive damages became an established part of American tort law, American courts emphasized the punishment purpose of punitive damages. In Hawk versus Ridgway, the court stated, where the wrong is wanton, or it is ill will, or it is willful, the jury is authorized to give an amount of damages beyond the actual injury sustained as a punishment, and to preserve the public tranquility. Did you hear that right there? The jury, not the judge, the jury. And remember back up a couple of sentences that says judicial decisions? Yeah, because that's what a jury verdict is. It's a judicial decision because they're the judiciary. And in this country, they're the only judiciary that can judge us because we don't trust government. Now, it kind of goes through and it talks about where awards have happened in history and what the amounts were, because it's going to talk about, well, how much is too much? What is too much? And it goes through all of this history. And I will link the article below if you really wish to read it. But it's not really important for what we're talking about right here. And I'm trying to get through this as fast as possible. Even after punitive damages were accepted in early American tort law, they were the subject of heated debate and skepticism regarding the remedial purpose. Concern was focused on whether damages should or could be awarded for non-compensatory reasons. And of course, that's kind of silly because we went through at the very beginning how time immemorial this law is. How time immemorial this law is. And of course, in my opinion, this was written by an attorney because they knew they had a problem, and we'll get to what the problem is by the end of this article. The purpose of punitive damages. Today, California courts have found punitive damages serve the dual purposes of punishing the defendant and deterring similar conduct in the future. Punitive damages are not awarded for the purpose of rewarding the plaintiff, but to punish the defendant. It's a punishment. That's really important, especially with what we're going to talk about. Punitive damages serve but one purpose, to punish, and through punishment to deter. You're trying to deter other people in society from doing the same things, from being bad doers, wrongdoers. We wish for everybody to act lawfully and upright and be courteous in our society. Accordingly, punitive damages should not be greater than the amount necessary to accomplish these goals. The function of punitive damages is served by an award which, in light of the defendant's wealth and the gravity of the particular act, exceeds the level of necessary to properly punish and deter. Depending on how much money you got to give up and how bad the wrong thing you did is, because we all know the difference from right and wrong, that's what the jury should kind of think about when deciding how badly to punish you. I mean, that's typically what you do when you're punishing somebody. The deterrence justification for punitive damages is motivated by two objectives. One, to deter the specific defendant in the case from repeating or continuing his, her, or its offensive behavior. Well, dang gum! It really seems like she should have left it at $5 million because I don't think Amber got the point. Especially since her attorney was on the morning show the next day saying, we're going to appeal, this is atrocious. This is so horrible, it's such an injustice. I don't think she got the point. 2, to deter generally other potential parties from committing similar offenses. And so those are the two reasons to do it. Make sure the person who did the offense doesn't do it again, and deter other people from doing it in the first place. Now, I'm going to read this one because this is really the case that really kind of brought me to this. I remember reading about this case probably 5 years ago. It was a pretty big case. It made it all the way to the Supreme Court. For example, in BMW versus Gore, a man sued because the brand new car he purchased had been partially repainted to cover damage caused while it was being shipped to the dealer. The jury awarded him $4 million in punitive damages. The Alabama Supreme Court later reduced the punitive damages to a more constitutionally reasonable, this is reasonable, $2 million, noting that in a case virtually identical to plaintiffs, another had received no punitive damages. So because this guy over here didn't get punitive damages, we're going to cut your punitive damages in half. The Supreme Court later held that even $2 million was grossly excessive. The Supreme Court was like, well, you can't do that. And the reason they're saying it's unconstitutional, just for people who don't sit around and read case law all day, the reason they're saying it's unconstitutional is it's kind of like that whole thing about excessive fines. It's a punishment. It's a fine. It's excessive. That's the entire argument for it. Determining how much is enough. Unlike compensatory damages, punitive damages are not recoverable as a matter of right. The amount of punitive damages awarded is left to the jury's decision. The jury gets to decide. The jury, not a judge, not a legislature. Because this is why the government cannot judge you. This is why we have juries. We don't trust government. And is determined by considering the character of the defendant's misconduct, the nature and extent of the plaintiff's injury, and the wealth of the defendant. Yeah, because you're going to have to punish people who are wealthier by charging them more, which is why $350,000 to a company like BMW is a joke. It's a joke. Jury instructions. This should be interesting. To determine the amount of punitive damages to award, the Book of Approved Jury Instructions states that the jury should consider 1. The reprehensibility of the conduct of the defendant. 2. The amount of punitive damages which will have a deterrent effect on the defendant in the light of the defendant's financial conditions. And 3, that the punitive damages must bear a reasonable relation to the injury, harm, or damage actually suffered by the plaintiff. Those are the 3 things that the jury should consider. How bad was the act? How much the defendant has the financial obligation to be able to pay, to actually have a punishment. And then what is reasonable for the harm, injury, and or loss. So I think that that's pretty common sense. And going kind of towards Amber's argument on that one, truth be told, she probably doesn't have a whole lot of money to pay with. She's probably a pretty poor defendant, especially right about now. And we'll get to that before the end. Punitive damages based on defendant's financial condition. And it goes through and it talks about some old English law, Magna Carta. Basically, you can't take more from somebody. You can't beat a dead turnip, right? You can't beat a dead horse into the ground. Just go get a shovel. I mean, that's basically what a lot of this stuff is going over. Talking about you can't take more than 10% of a defendant's net worth, 15%, and what the courts have found reasonable in different places. If you wish to read a lot of this, then I'm going to link the article below in the description. You can go check it out. This is the BMW case again, okay? The other indication of whether punitive damages are reasonable is the relationship to the actual harm caused. Courts have long held that punitive damages must bear a reasonable relationship to actual damages. In the BMW case, there is no magic ratio, however, between the maximum permissible punitive damages and compensatory damages, and juries have wide discretion when deciding whether punitive damages should be awarded. Except for now. Now it's legislatively capped at less than $1 million, even when the defendant is a multimillionaire. More recently, the Supreme Court decided in the BMW case In that case, Dr. Gore bought a new BMW automobile for just over $40,000. 9 months later, a car detailer noticed that parts of the car had been repainted. At the time, BMW had a policy that it would not sell as new any car with pre-delivery damage that totals more than 3% of the car's suggested retail price. The cost to repaint the BMW at issue was about $600, which was only about 1.5% of the suggested retail price. Thus, the repainting was not disclosed when Dr. Gore bought the car. Dr. Gore sued BMW, claiming that BMW's failure to disclose that the car had been repainted constituted the suppression of a material fact. He claimed that the actual damages were $4,000 based on a testimony of a former BMW dealer who said a repainted BMW was worth about 10% less than a car without the repairs. Dr. Gore also asked for $4 million in punitive damages. He arrived at this figure by multiplying the $4,000 in actual damages he suffered by 1,000, the approximate number of new cars BMW sold with undisclosed repairs. Here's where the problem really comes in my opinion, is because Dr. Gore did not come up with that legal argument himself. An attorney came up with that legal argument, probably because the attorney was working on contingency. If we win millions of dollars, I'll take a third of whatever we get, and I'll do the case for free. And so I'm sure that attorneys working on contingency had a whole lot of motivation, millions and millions of motivations, to get that punitive damage as high as they possibly could, to get outrageous court awards and court judgments from juries, like $4 million because of a scratched BMW. And that's the real problem. The jury awarded Dr. Gore exactly what he requested, $4,000 in compensatory damages and $4 million in punitive damages. On appeal, the Alabama Supreme Court held that the amount of the punitive damages awarded was not excessive, but that the method of calculating was impermissible. Yeah, you can't tell the jury how much they're supposed to give you in punitive damages, because that's the whole problem. In my mind, this is why punitive damages went from something reasonable to something astronomical in less than half a decade. Is because attorneys got their filthy little hands on it. They abused the system, and now the rest of us have to pay for it. And big corporations like BMW or Target or Walmart, where people have slip and falls or whatever happens and they go get an injury lawyer, those are the cases where Walmart, BMW, Target, they all have a whole lot of reason to go and pay a whole lot of lobbyists to make sure state legislatures put these measures in place so that whenever they do get sued, they're not looking at some astronomical lawsuit. And in some cases, they really should be punished that way. In cases where they just do these things because it's the cost of doing business, because if they get caught, they're still going to make out like bandits for all the times they didn't get caught, which is exactly why punitive damages are there in the first place. That's basically it. And again, I'm going to leave a link to this article below. I just wish to read the conclusion. The conclusion: the appropriate measure of punitive damages is a subject that we will be closely watched in the next decade. With the clamor for reform of punitive damages, and we already have that reform of punitive damages now. You just saw it in the Johnny Depp turd case. Legislatures are being inundated with lobbyists peddling bills to reduce or eliminate these damages. Courts are likewise being pulled by arguments of due process, unlawful taking, and excessive fines under the various clauses of both the federal and state constitutions. While the fact of such damages will be decided by either the legislature or the courts, at some point limits may only act to erode the confidence of the public in our legal system by abandoning the only remaining civil process that penalizes a party for the act of fraud, oppression, or malice against another. This is the only way that we as the public have to civilly prosecute acts of crime, criminal activity that happen against us. And the legislature has just legislated that away. And the courts are upholding it. So I'm going to ask you, what do you think about that? And what I really love about this statement is where he says right here, at some point, limits may act to erode the confidence of the public in our legal systems. They recognize that by doing this, it could erode the confidence. But you want to know what? They all think you're too stupid to care, to notice what's actually going on. That's why they let go of the jury before they said, we're going to knock that $5 million down to $350,000. They don't need to know what's going on, though. This is the joke our legal systems become. So I was really upset about it, obviously. I'd still like to hear your opinion and know what you think. But this actually made me feel a lot better because I figured that the turd would just declare bankruptcy no matter what verdict she got. So let's see what happened here. Law and crime. Amber Heard would gain no real benefit by using bankruptcy to avoid paying Johnny Depp millions, but there's a catch. Law professor says, and the only thing I'm really interested in is right here. The analysis starts with 523A6, whatever that means, of bankruptcy statutes, not law, statutes. Oh, Sovereign Lord, please tell me how to live my life. It says that a discharge of debts under various other sanctions of the law does not discharge an individual debtor from any debt for willful and malicious injury to the debtor, to another entity, or to the property of another entity. And basically what that's saying is that even if you declare bankruptcy, it's not going to help you in bankruptcy court against a judgment where a jury found that you maliciously did something to hurt somebody. You willfully and wrongfully, against your own conscience, or at least the conscience of the jury, did something to hurt somebody. So even if Amber Heard goes in and files for bankruptcy, that $8.35 million judgment after you subtract the $2 million that she was awarded will follow her around for the rest of her life, or until she pays it off, unless Johnny just doesn't care about enforcing it. Anyways, what do you think about that? What do you think about the judgment? Do you think that the state has the authority to take away our right to law? If so, why? And one thing that I do think is because the compensatory damages for sure should be upheld even if she declares bankruptcy. What about punitive damages? Because that's just a punishment. Should those still be upheld in a bankruptcy? Let me know what you think. Anyways, we are just conspiracy, and we just wish to conspire to bring heaven down to earth. One world, love, and peace. Alright, thanks for making it this far in the video. I really appreciate it. Something that kind of came to my attention while I was processing this video, that is Taylor Lorenzo of the Washington Post has put out an article which lied about my man, the umbrella guy.
Hi. If you're watching this far, don't forget to like, subscribe, click that bell to never miss another video, and share the video because YouTube algorithms won't. Your only hope.
Your only hope.
Now I disappear.
So Taylor Lorenzo is a columnist who writes for the Washington Post. The Washington Post is the exact same entity that put out the piece for Amber, which she just got sued over. And again, the whole idea of punitive damages is to make sure that nobody else repeats the same behavior. And here you are within a week, less than a week, of the verdict coming down. And Taylor Lorenzo, for the same newspaper that put out the defamation piece in the first place, is now defaming at least that umbrella guy and lying about him and saying she tried to get a comment from him and she did not. It has been on Fox News and the internet's kind of buzzing about it. So this is a pretty good argument for why you should have punitive damages. Another thing I'd like to add is that the jury probably, because in my mind, there's no way that that they were going to give Amber anything. I think that Amber's the one that they didn't write down any damages for because they left the punitive damages as zero and they came back pretty quickly. So my guess is the argument for her to get $2 million is that, well, he got $5 million in punitive damages and they're just going to take that away. And if you think about that and the logic of that, which seems pretty sound to me, it's really like Amber Heard kind of won $6.65 million because $4.65 million was just thrown out right out the gate. $4.65 million that she would have been liable for, the courts just got rid of. So these are just a couple of things to think about when thinking about the idea of punitive damages. But it really is a discussion that we should have because the common law is made by us common people and not by legislatures, judicial officers, and government historically. They create their own civil law for their own civil purposes. I don't know how civil it is, but that's how law works. Anyways, thanks for joining. Bye.